I want to refer now to the already disseminated survey, which is not a repetition, even if there are some points overlapping. Between 9th September and 3rd of October 2008, the Human Rights Center, University of California, Berkeley, conducted interviews of randomly selected 1,000 Cambodians over 18 years old and examined their attitudes about social reconstruction and the ECCC. The survey was published recently and does not provide new facts, but complies with and confirms already submitted general arguments of the still unstable Cambodian post-conflict society. We would like to highlight some results of this study. 84.6% of the respondents who lived under the decay period said that they have feelings of hatred towards those Khmer Rouge responsible for violence. These are in average 82.9%, including those who did not live under the Khmer Rouge period. On the question if the respondents wished to could take revenge, still 35% agreed. And nearly 40% of both groups wished to take revenge if they could. 71.5% wished to see those responsible hurt or miserable, and only 1/3 have forgiven the Khmer Rouge. Asked about their attitude towards the Khmer Rouge, still 12% in average want to kill them and 5.7% want to torture them. The result shows clearly that a high potential of violence is still at place. From a Buddhist perspective, this does not contradict feelings of anger or hatred resulting from past experiences and fueled by attitudes and negative stereotypes toward the Khmer Rouge, who are seen as the enemy. The study shows that people could rather forgive individual Khmer Rouge, but still have feelings of anger towards the leaders or the Khmer Rouge violence in general. Last but not least, the behavior of Ieng Sary, wife of the charged person with whom he meets regularly, during the appeal hearing gives reasons for, or her appeal hearing better, give reasons for serious concerns. The co-lawyers for the civil parties do not deny her right as a charged person to disclaim the charges, but she went far beyond when she threatened the prosecution and the civil parties by intimidating both, and I quote, "Don't accuse me of murder, otherwise you will be cursed to the 7th level of hell."
Your Honor, at this point I will be objecting. I will be objecting.
Please, I want to finish.
I'm entering an objection on the grounds. No, I'm sorry.
And it is nothing to object, and I think you have then 15 minutes to respond. And this was a public event, public appeal hearing to which I can refer, and I give only examples to give reasons why here the public order and the safety of the charged person is at risk. I'm at these points, and of course I can illustrate this by enumerating events.
Your Honors, we just heard.
Please, I want to ask the Chamber to intervene, please, because I do not want to be
just a moment.
At this point, Your Honors, I entered an objection when the prosecution stood up. I yielded the floor. He made his objection. There was a record. The bench turned to me and asked me to respond.
Yes.
I stood up. I objected. The madam continues to speak. I just got a lecture about not generalizing the civil parties. Now she's generalizing about my client's wife, about her being, because this procedure is not about that procedure. And one has nothing to do with the other, and I don't think it's relevant. So on the grounds of relevancy, I'm objecting, and I'm asking for a ruling.
I think you made your point in response already to what Mr. Carnevas raised, and if you wait a minute, we will provide a ruling.
Could I add something, because he finalized just now. This is not to the content this is not generalizing. I focus on special events that occurred here in this court, and I describe these. And I think there is no doubt that the quotation, how I quoted her, is disputed or objected. I think the quotation was right, and so it is not to generalize. Then I must object this objections of the defense. Thank you.
Thank you. I think it was clear already in the first round where you replied on the objection. The pre-trial chamber allows the lawyer of the civil parties to continue with her pleadings, and the pre-trial chamber finds that what the lawyer is doing is stating facts with to demonstrate that public order is still disturbed. And insofar facts are raised which will be considered irrelevant by the pre-trial chamber, they will be reasoned if the pre-trial chamber finds so.
Yes, thank you, Your Honor. I continue. Yes. I was in the middle of the appeal hearing of Ieng Sary and repeat the last paragraph that I wanted, the last sentences, 2 sentences that I want to submit. The co-lawyers for the civil parties do not deny her right, Ieng Sary's right, as a charged person to disclaim the charges, but she went far beyond when she threatened the prosecution and the civil parties by intimidating both, and I quote, "Don't accuse me of murder, otherwise you will be cursed to the 7th level of hell," unquote. According to Cambodians' beliefs, the 7th level of hell is a term for the realm for ghosts at the 7th level. People believe that this location is a very bad place where ghosts live after some people died, because those people committed very sinful actions against others. That means to be cursed at the 7th level is a very strong threat and makes people very scared. Even if the charged person did not threaten himself, civil parties and victims, these threats must be taken into account for the assessment of security of the charged person and related to the public order. Likewise, other menaces from Prime Minister Hun Sen, who warned that prosecuting Ieng Sary will cause war, or by his son, who warned to charge his father must be seen as puzzle pieces for the whole. In this climate of tension, which causes again fear, but as well anger among some of the civil parties, which could result in verbal and physical attacks against the charged person. To conclude, the recent clash between some victims, respectively civil parties, and the Defense Council reflects the readiness to express anger to the extent of violent attitudes, at least to senior leaders, and instead of reaching those, this attitude is directed against Defense Council. The incident is in full accordance with the results of the survey and mirrors the fragile society where coping mechanisms for the immense sufferings have never been developed nor practiced. The ECCC works somehow as a trigger which leads to the breaking off of long-hidden pain. Therefore, the co-lawyers for the civil parties note that the outbreak of violence of parts of the civil parties is probable and could result in public disorder and putting the security and safety of the charged person at risk. Only one of the conditions of Rule 63(3)(b) needs to be accomplished to justify the necessity of provisional detention. The recent event sets grounds for two elements that are required to justify the extension of the detention order. The defense submits that the objectives of Rule 63(3)(b) are protected by conditions of house arrest in the same manner as provisional detention can do. The co-lawyers for civil parties recognize that house arrest can be held as a form of detention. However, it is considered as less rigorous than incarceration, and it is most likely that those victims and civil parties who have expressed their anger do not perceive house arrest as a form of detention and will consider such a measure as an enhancement for the charged person to the effect that their anger puts the safety of the charged person at risk and disturbs public order. In light of the results of the Berkeley survey, and the incident in December 2008, house arrest does not reduce the risks for public order and the risk for the security of the charged person. Therefore, the necessity of provisional detention is given further on. I would like at the end to focus on one confidential matter and request the pretrial chamber to be allowed to submit the last point that I want to submit at the end in closed session. But before finishing in public session, I would like to give a comment on the request of the defense to not decide after this hearing of today and to continue in June in order to include arguments on corruption. We submit that the corruption matter, which was not raised in this appeal within the deadline, may be discussed within the pending application. Therefore, we request to reject this defense motion. And so I end at this point because we have here the family of the charged person sitting and others, of course, who can follow the hearing, so that I would like to continue my submission in closed session later on. Thank you.
Just one point. I do take exception, and I hope it never occurs again, where a lawyer points to the audience and makes a comment about somebody in the audience being related to an accused. I think it's totally inappropriate. And if somebody wishes to bring harm to another individual, that's a perfect example. And I think if we're going to be respectful of the civil parties, let's be respectful to the loved ones of those who are accused.
The President, the defense counsel of the charged person, would you like to make further comments on top of what you already addressed?
1 second. Yes, Mr. President, my apologies for being clumsy here. I'll be very brief, and I will touch on the points, but I will probably start with the very last point, the issue of public safety. I do think this is a rather important issue that needs to be discussed, and I will be discussing it in the context of this particular report, because here it would appear that it started with the prosecution, it then moved on to the civil parties, and it would appear that now we're going to be asking a court of law, judges, to be making decisions based on polls, is what I called on several occasions the court of public opinion. Now let's take this argument somewhat further. If public sentiment is such, and if Cambodia is so fragile and is about to erupt into a tsunami of violence, if someone is provisionally released under strict conditions and supervision, imagine what would happen if at the conclusion of the trial the evidence pointed to a not guilty verdict. By that argument, if you were to buy that reasoning, you would have to find the person guilty even if the evidence didn't warrant it. Otherwise, you may have public violence on your hands. And that is what is being suggested here today. That we look at polls and we use polls to determine whether somebody should be provisionally released. Tomorrow we will use a poll whether somebody is guilty. And based on these polls, we will decide, even if the facts don't warrant guilt, we nonetheless should find the person guilty so that we can protect the public and protect society from itself because of an inconvenient judgment. Which is why I don't think that in this particular proceeding, or any proceeding, we should be relying on polls to determine how you, as independent and impartial judges, should be viewing the evidence. I don't think that in my jurisdiction in the United States, a lawyer would even be allowed to make such a claim that a poll was taken and therefore a judge should use his or her discretion based on the poll to make a decision. I don't think that we should be doing it here in Cambodia. But if that is indeed the case, as they suggest, then it begs the question, how is it that the prosecution, or at least one of the prosecutors, the international side, is pursuing aggressively the charging of more persons when you have Mr. Hun Sen himself saying that I will not allow Cambodia to have another war? That's the Prime Minister's take. So when it comes to charging more people, the prosecutor is not worried about the fragile circumstances of this particular society or country. And the Prime Minister is a very, very wise man. And he knows, and he's come out and said it. Nothing will happen. We don't have the data. That's just a few rumors and innuendo. But when it suits them, they will pull out another study to say that based on this study, no one of the accused thus far can be safe on the streets. We do apologize, and I say this with all due sincerity, if we have offended any of the civil parties by grouping them, by generalizing. The facts, as was related by one of the counsel for the civil parties, was accurate as far as what had happened. Obviously, that incident was with respect to one civil party, so we do apologize if in any way we impugn the integrity of all civil parties. That was not our intention. But what we were trying to, the point that we were trying to make is, you can't have a civil party verbally or physically attacking a lawyer or threatening a particular accused and then turn around and use that bad behavior as the reasoning of saying, there's going to be civil unrest, they're not safe. That was the point. And perhaps I should apologize for not being clear in stating our position, but that is indeed what we were trying to argue. Not that the civil parties are doing that, but at least there are some who feel very strongly and act poorly, and that poor behavior should not be rewarded, and we believe that that's what would be the case. And I really don't think that there is sufficient evidence before you, Your Honors, to suggest that someone who is detained in his own house poses a threat either to himself or to others. Certainly, given Ms. Ieng Sary's condition, his age, which was recognized by one of the civil party lawyers, is rather advanced. You can see that he's hardly, or barely I should say, ambulatory. He is not the sort of person that might run away. And speaking of age, because the prosecutor stood up and said, even 8 years is enough. If you're accused, and the subtext is, of course they're guilty, so it's okay to hold somebody for 8 years. That is the subtext, because what if that person were to be found not guilty? How does that person get his 8 years back? He doesn't. But the innuendo is, or the subtext, is that holding somebody up to 8 years is perfectly okay. And let's run with that. Let's develop that a little bit. If that individual is 20 or 30 or maybe even 40 years, 8 years may not be that much. For 40 years, you get out, you're 48, that might be okay. When you're 80, 82, 83, 8 years of detention or 3 years of detention or 1 year of detention is a lot more than 1 year for a 25 or 40-year-old. There's a big difference. And the change of circumstances, they say, where are the change of circumstances? Well, and they cite what representations I made at a particular hearing on that particular day. What the prosecutor failed to bring to your attention, Your Honors, that was slightly thereafter, that circumstances did in fact change because of his advanced age. We don't know from one moment to the other whether he is going to be over here in a relatively good and cheerful mood, able to carry on a conversation, or whether he needs to be rushed to the hospital by ambulance because he needs immediate medical attention. Those circumstances change from day to day. So it wasn't very far or very long after that particular hearing, which lasted about 15 or 20 minutes, that his health did change and that he went into the hospital on several occasions. And so, well, those are the circumstances that have changed in part. Which brings me to one point, and perhaps we may need some guidance from the pretrial chamber on this one, because if the issue is, where are the change of circumstances, are we, from the moment that we make a filing, a submission, there is a lag of time to the point when it comes before you, either for a hearing such as this, or where we file a reply and you have to make a decision. And this is a very fluid situation, especially because of the advanced age and the physical health of our client. Are we to file notices with the trial chamber, with the pretrial chamber, that the circumstance has changed on a periodic basis? If that is the procedure, if that is indeed the procedure, I apologize for not applying it, and we will do so in the future. But perhaps this may be something that the pretrial chamber may wish to consider and give us some guidance. But as I understand it from reading the decision that I had read earlier from 17 October 2008 in Paris 68 to 69, at least factually speaking and legally speaking, you were to consider whatever is in the case file. And of course, these changed circumstances may not necessarily be in the case file, but we do think that when something comes up right before a hearing that is relevant to the hearing, we should make it part of the hearing. And that was what we were trying to do earlier with our submission, which was dealing with the issue of due diligence, which was tied into the length of the investigation and tied into allegations concerning findings by a UN office that one particular individual at a very high place was engaged in corrupt activities, and of course the budgetary issue which I alluded to earlier. We believe these are changed circumstances. We would suggest that a hearing would be appropriate. However, we do understand that these sort of proceedings should be dealt with in a finite period. So what I would propose, Your Honor, because it is out there, we're not asking for you to do any investigation. What we are asking to at least be allowed to brief the matter. We believe it is an important matter because of the age of our client and because of his health, because of the continuing length of the investigation, and especially since, if you look at Article 28 of the agreement, it makes it very clear that if circumstances change at some point, the UN is perfectly within their right to cease to provide assistance, financial or otherwise. And these are it's almost verbatim text which was quoted by Mr. Knut Rosenhag. At least that's what he's being quoted in this report by the German delegation, where he himself said the report that was provided by the United Nations and had named Mr. Ieng Sary was the one individual who was at the apex, and they had, at the UN had found that he was guilty of corruption. That's what is in the report. So we do believe that this is something that should be considered, because if this institution may change in its appearance, it may go national as opposed to the hybrid. If the core investigative judges will need extra time to consider whether any of the evidence that they have considered has been tainted, because I want to be very, very clear, we are not making any suggestions that anything has been tainted.
Excuse me, Mr. Cannabis, are you not now addressing us on a matter that we said you should not be addressing us on at this point?
I'm simply replying to the response.
No, I think you are going further than that.
I will move on.
Thank you.
And I'll just touch on a few other points. If I may start now from the beginning, dealing with the health issues, it was raised, I mean, maybe I didn't quite understand the argument that was being made, but it seems to me that the prosecution's understanding when it comes to being provisionally released due to health is only after there's some sort of a medical finding that you're about to die, that you don't have very long to live. There have been some instances in The Hague where that has happened. I believe it was General Talich was one of them who was released early, and shortly thereafter he did die. However, as I mentioned in the last time that we were here, and I believe it might have even been last year ago, the Stanisic case. And I'm rather astounded that the gentleman wasn't aware of the case, because Mr. Stanisic has yet to go to trial, and this individual held the position of being the head of the Secret Service of Yugoslavia, who perhaps knows more about the events than Milosevic himself. And of course, he's a very high-valued accused, charged with very serious crimes, and yet because he had a stomach ailment and because of depression, the trial chamber found that he was not physically fit or mentally fit to go to trial. The trial had begun, and a day or two later it stopped. So here is a very good example where health in and of itself can mandate provisional release, because that's what happened. There was a determination that he would be better served being in Serbia being treated by his local doctors as opposed to being treated in The Hague, in Scheveningen, where they have the UN detention center and where they have the UN doctors. And so he was provisionally released based on a guarantee that was provided by Serbia, and that's where he remains, as far as I understand. That's where he was prior to my departure to come here to Cambodia. So there is a very good example. But that ties into my other point. If we are unable to assess at this point in time our client's ability to assist in his own defense, either physically or mentally, and from Dr. Falk we have that, at least we have some inkling that we don't have the necessary tests because they were never performed. How can we possibly then argue to you that at this stage of the proceedings he's not fit to stand trial? The one gentleman, and I was rather surprised, I must say, because I understand some of the lawyers for the civil parties are also defense lawyers, I was rather shocked to hear that he mentioned that my client has decided to exercise his fair trial right to remain silent, and therefore that was a complication. This is the first time I hear that exercising one's right becomes a complication. I don't think that exercising one's rights should be viewed in that fashion. But you must keep in mind that in order for someone, assuming that he wishes to assist by not exercising his right to remain silent, in other words, providing a statement, he does have the right to assist in his own defense by being able and capable of reading what's in the file, the dossier, what is being collected. And it was precisely for those reasons, on several occasions, I brought it to your Honor's attention in our motions, that part and parcel of the right to assist in one's own defense is the ability to understand, comprehend, and to contribute after reading the documents and speaking with the lawyers. And it is rather presumptuous that the gentleman sits here and says, well, he exercises his human right to remain silent, and therefore we can draw some conclusions, rather than saying, well, perhaps one of the reasons may have been because he's unable to assist in his own defense because of health, his physical health and mental health, his age. So I just put that out there as a point, as a counterpoint. There was an argument made that house arrest was a thing of the past. It was passé, as it were. Something that the International Criminal Tribunal for the former Yugoslavia sort of experimented in the Blaskets case and afterwards gave up on it. We have to understand one thing. The ICTY, first of all, is an international court. Secondly, it negotiated an agreement with the Netherlands. Thirdly, the Netherlands made it very clear that they didn't want anybody provisionally released while in The Hague. And there's a very fine case on that point. It's the Blagojevich-Jokic case, where Judge Schomburg did in fact find that someone could be provisionally released, and the Dutch government the next day came to court, and their diplomat said that the decision was, and I quote, abhorrent. And the reason I say that is because I was present when that happened. So you cannot look at the Netherlands and say, well, oh, the Blaskets case, and say, well, they just gave up on it. Because if you fast forward a few years, and I'm sure that my learned colleague here, who comes from the Office of the Prosecution from the ICTY, would have known that in the Biljana Plavsic case, who was the political twin of Karadzic and Krajisnik, the Troika of the Republika Srpska. Karadzic was the most wanted man other than Mladic. They were on the same level. And even before she decided that she would plead guilty to a reduced charge of 1 count of persecution, she was provisionally released in Belgrade under house arrest. Not only that, Your Honors, but when she pled guilty, she did so via video link from Belgrade, as I understand, and she continued to be under house arrest until sentencing. Now let's look at the circumstances there, because the former Yugoslavia, Serbia in particular, has been noted in the press for being a rather volatile area where the sentiments run very high against the International Criminal Tribunal for the former Yugoslavia. And here it became known to God and mankind that this woman was going to not just plead guilty, but was going to implicate some of her highest associates. And that never once did anyone question whether now we need to bring her back to The Hague, back to the UN detention unit, because house arrest was dangerous to her health, that they could no longer protect her. So when they say that that's an issue, that's something passé, there's a more recent example, a very high level individual, a volatile region, pleads guilty, names names, takes on responsibility, and also claims that others are responsible for very serious crimes, and yet she's allowed to remain under house arrest while waiting to be sentenced. And keep in mind that after you plead guilty, your status changes dramatically. You no longer enjoy the presumption of innocence. You pled guilty, so therefore, once the court accepts the guilty plea, you are guilty. So I raise that just for your understanding. The Dutch case came up, and they say, well, he's being tried in this, doing whatever he was doing. And it's our submission that at this point in time, any suspicion or innuendo is just that. There's no hard evidence, none that is before you, and I don't think that you need to give that any weight. Otherwise, we're just going to be speculating, and we're going to be finding people guilty by association, because that's what that argument leads to, and which is exactly why I was rather quick to my feet and rather, I would say, direct and sharp with my colleague for the civil parties when she brought in my client's wife, because what she said, what she did, under what circumstances, has nothing to do. But very cleverly what she said, that my client sees his wife on a weekly basis. And therefore, you see, there you go. They see each other. So therefore, what the wife says, you must attribute also to the husband. That's the underlying argument of that. Pernicious as it may be, I don't believe that it has any weight for you to consider. What she did or what she said is irrelevant in your determination as to Mr. Ieng Sary is not a flight risk, a risk to himself, or a risk to others. The issue as far as the UN detention unit being sort of enjoying the stamp of approval by the United Nations or other organizations that have looked at it. What we're not saying, and nor do we want to be left for you to be left with the impression that we're saying that it is some inhumane place. That's not what we're saying. What we are saying is, due to his age and due to his health, that may not be the best suitable place. And so that's the argument. I want to make sure that you that I'm not misunderstood. But when they have the temerity to say this is UN approved, and then I bring in, or try to bring in, a UN doctor from the other sister organization who looks after all of these accused, who says, from my quick study of the medical reports that I have, it appears that at least 2 major examinations are not being provided to this individual, examinations which are standard, in order for us to determine whether the person is fit to assist in his own defense, to enjoy his fair trial rights. When it comes to that, they are very dismissive. He is over there. He hasn't looked at it. He's only a generalist. They do everything they possibly can not to hear the particular individual. And so it begs the question, how can on the one hand they say this is UN approved, and then when I bring in a UN doctor who is the doctor and oversees all of the accused for the International Tribunal of the former Yugoslavia, the ICC, Mr. Taylor, who is a guest over there from the Sierra Leone court, and probably the Lebanese. So I don't see how they can say this individual is not qualified to be heard, at least on the very limited nature of whether these exams are given and should be given in this instance based on the records that he has heard. Yes, sir.
A brief submission that my learned friend is seeking to re-argue an application that in two different forms have been rejected in the very recent past. And I was wondering whether Your Honor would let that continue. Thank you very much.
I'm not arguing, Your Honor, that he be heard, but he invoked the UN standards, and that's my reply. And so if he didn't want to hear what I had to say about Dr. Falk and his qualifications as a UN doctor, then he should not have raised the issue that this place over here enjoys the UN seal of approval. I believe I've covered all of the points that I wanted to cover, Your Honor. Again, I want to thank you very much for giving us this opportunity to be heard. We would appreciate, and this would be an oral submission, to consider either continuing so we can have make further submissions so that there are no claims of not being duly noted, or give us the opportunity on, say, 10 or 15 days to provide written submissions for you to consider. So those were our requests. Again, we thank you very, very much. We apologize if we were overly aggressive at any point, but we certainly appreciate your indulgence. Thank you.
The pre-trial chamber rules on the request to delay the hearing in order to allow the defense to make additional submissions, as how the pre-trial chamber understands the question raised, either orally or in writing. This is the same issue involved. The pre-trial chamber denies this request because the pre-trial chamber finds that the way the co-lawyers have put this request before the pre-trial chamber is of a speculative nature, and as it is asserting that if this delays the hearing, it should have consequences, and then raises the issues which are concerned. The pre-trial chamber finds that it's only taking in consideration facts as they are relevant and are present at this moment, and not speculative facts which may. The pre-trial chamber also notes that there's a possibility for the defense lawyers to ask for release of the charged person if the circumstances are found that influencing the way the proceedings are going on. So there is a possibility. So that's why the pre-trial chamber denies the request. Just to be sure, the charged person has left, and the defense has made clear that he doesn't want to be present here anymore, but does he also waive his right to speak last in these proceedings?
I'm glad that, thank you for the ruling. And I should have made it clear that prior to the commencement of the proceedings, again, we did consult with him after the lunch break.
Yeah.
And he wasn't feeling well, so he gave us permission to continue the hearing in his absence. And he had indicated that he does not wish to make a statement. He communicated that to us, and for the proceedings to close in his absence. And of course, it should be understood, but I guess I have to say that the waiver was only for today, so it's not sort of a continuing waiver. Thank you.
Thank you.
President, I would like to inform the public that after this public hearing, we will have a break, and when the court resumes, it's going to be in camera. And I would like to inform the public that the order or the decision of the trial chamber will be notified 3 days before it's going to be delivered. Therefore, I declare the adjournment for 15 minutes breaks, and when the court resumes, it's going to be in camera.